Foreign Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is a U.S.-based service provider offering IP docketing and paralegal support services and annuity services. The SLW Institute is an educational group created by the Schwegman-Lundberg-Wissner firm, which aids to provide insightful and useful information to the IP community. For this webinar series, we have pulled together experts to talk about strategies and best practices for patenting in key foreign countries. The Foreign Excellence webinar series is free. This is the second one of several monthly webinars in this series. The schedule and registration information for upcoming webinars is listed on our website. To register for future webinars, go to the tab for Educational Resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today will cover Japan specifically. We have allowed time for questions at the end of the webinar. Questions may be submitted using the question button on the right-hand side of your browser window. You can submit a question at any time during the presentation, and the question will be held in a queue until the end of the presentation when we will discuss them. Let me get my slides advancing here. There we go. The presenters today are myself and Shige Takeuchi. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Shige, can you please introduce yourself?
Yes, thank you. Hello, everyone. My name is Shigeki Takeuchi. I'm happy to have the opportunity to give the presentation today. I'm a Japanese patent attorney working at Ocean LLP, the Silicon Valley office. I have moved from Tokyo this September, so I'm in the middle of adjustment to the new life. Before coming here, I worked in Ocean Tokyo office and the Japanese patent firm, and I have been engaged in patent prosecution in both countries over 10 years. I hope today's webinar helps your and your client's business in Japan. Thank you, Anne.
Thank you very much. Again, there we go. Today we're going to talk about some patent filing trends in Japan, and then also very specific details and overview of the patent process in Japan. The first slide here shows some market comparisons just as a backdrop for our discussion. The population of Japan is 126 million. To compare that to the U.S. and China, the U.S. population is 326 million, and the Chinese population is 1.38 billion. These three countries represent the three largest economies in the world based on GDP. Japan and China, for that reason, are countries that many U.S. companies consider filing patent applications in if that company is going to file outside the U.S. Hold on here. Okay. The next slide looks at the top patent assignees in Japan and breaks those out by U.S. companies, or I'm sorry, not U.S. companies, but Japanese companies and non-Japanese companies. As you can see from the red line, which represents the number of applications, I'm sorry, the number of patents granted each year to Japanese companies compared to the blue line, which represents the number of patents granted each year to non-Japanese companies, there's a big difference in the number. The top 7 Japanese companies with patents granted in 2016 had between about 1,900 up to 4,400 applications or patents each granted in 2016. Those companies are Panasonic, Canon, Mitsubishi, Toyota, Denso, Seiko Epson, and Honda. Comparing that to the non-Japanese companies with patents granted in 2016, the top non-Japanese companies had between about 275 patents for Intel and 1,059 patents for Qualcomm. Of those non-U.S. companies, 4 of them are U.S., or non-Japanese companies, 4 of those are U.S. Those are Qualcomm, General Electric, IBM, and Intel. Now looking at the technologies that are covered in applications filed in Japan, the top 10 technology areas are shown on this slide. And this is regardless of whether it's a Japanese or a non-Japanese company. The top technology area is electrical machinery, apparatus, and energy, which accounts for almost 9% of the application filings per year. That's followed by optics, audiovisual technology, computer technology, and semiconductors, each of which account for more than 5% of the applications filed in Japan. So clearly, companies in the computer and electronics field are regularly filing in Japan. Now let's look at the patent filings specifically by non-residents. The term non-resident here refers to a foreign applicant in China or a foreign applicant in Japan. The next 3 slides will compare patent trends in Japan and China. And as we discussed last month, we looked at in detail at the patent filing trends in China. So we're now pulling these in and we're going to compare them to the filing trends in Japan because these are such big markets for many U.S. companies. In this case, the red bar shows the patent applications filed year by year for foreign companies in China between 2010 and 2015. The white bar shows the patent applications filed each year by foreign companies in Japan. This data comes from WIPO, and in this case, the number of applications filed by foreign applicants in China has increased each year. However, the number of applications filed in Japan by foreign companies has stayed relatively level. The difference is not significant. Between 2010, there were 54,517 applications filed in Japan by non-residents, and in 2015, that had only increased to 59,882 applications filed by non-residents. Also, if you look at the number of applications filed each year in China, it's roughly twice the number of applications filed by foreign companies in Japan. This chart looks at the patents granted in Japan and China to non-residents. Again, the red bar shows the patents granted each year to foreign companies in China, and the white bar shows the patents granted to foreign companies in Japan. There's more patents granted in China to non-residents than in Japan, which makes sense in view of the numbers on the last slide we looked at, where there were more filings in Japan, or I'm sorry, more filings in China than there were in Japan. One thing that's interesting to note, and I don't have an explanation for it, is that the Japanese patent grants jump up slightly in the 2013 and 2014 years, and at the same time, the Chinese patent grants dip slightly in 2013 and 2014. Probably not enough of a difference here, though, to be significant, but it was interesting to note. The next slide looks at the total number of patents in force in China and in Japan, regardless of whether these are held by residents or non-residents. And again, red bar shows China, white bar shows Japan. Both countries show an upward trend from year to year in the number of patents in force. And in this case, though, there are fewer patents in force in China than there are in Japan, which also, if you listen to our last webinar, makes sense because the Chinese patent system has not been in existence as long, and to me, I think that's an explanation for why there's fewer overall Chinese patents in force than the Japanese patents. Last, I want to look at the cost of a patent over the lifetime of the application and the patent before I turn this over to Shige. The total cost between the lifetime of a patent in China and in Japan is relatively similar, although in Japan it's a little more front-end loaded with more costs coming in the patent acquisition or the patent prosecution phase, and then a little less cost for the annuities to maintain the Japanese patent, comparing that to China, where it's not quite as expensive to go through the prosecution process, but the Chinese annuities cumulatively come to more. At this point, I'm going to turn it over to Shige to walk through the patent process in Japan.
Okay, thank you, Anne. Now, I will explain the overview of the patent process in Japan. Before that, I believe you know the patent prosecution procedure in the United States very well, so I will focus on the difference of the system between both countries. For today's webinar, I chose 3 topics in the prosecution procedure. But before explaining these topics, I will explain the flowchart quickly. At step 1, you file an application, and then JPO conducts the formality examination, and then proceed to the substantive examination. Step 4, a request for examination. This is one of the major differences between Japan and the US. I will explain this later, so here, please just understand that you need to take another action to proceed to the substantive examination. And at step 7, notification of reason for refusal. This corresponds to the first or final office action in the United States. And step 8, you file a response to the office action, and after receiving the response, the examiner considered your arguments, and if the examiner reached the negative conclusion, the process goes back to step 7 again. And I think this chart is a bit strange because there is no substantive examination between steps 8 and 10. The examiner must consider the response to the final section, of course. After the examination, if the examiner considers your argument not persuasive at step 10, decision of refusal will be issued. I think this step corresponds to the advisory action. This is the final decision, so we usually cannot respond to this action except the notice of appeal. I will skip the explanation about the remaining steps, but similar to the US, there are chances for the issued application to be invalidated by appeal for invalidation procedure at step 15. This step is similar to the post-grant review in the United States. Now, I will explain the big 3 topics about the differences. First, a request for examination. As I said, in Japan, you need to submit a request for examination within 3 years from filing to have the examiner examine the application. Otherwise, the application is considered being abandoned. In other words, your immediate payment of the examination fee is not required. The amount of examination fee is over $1,000, which accounts for a significant proportion of the official filing fees. So it is a common strategy for Japanese companies not to file the examination request on filing for securing time to determine whether they need to pursue the protection by that invention. You can use that strategy, especially when your client is not sure they need protection in Japan and want to defer their decision, or when your client simply wants to save initial cost. The second difference is requirement for amendment. I think this difference is very important in our practical business. There are many differences on amendment requirements depending on the prosecution stages. But here, I want to tell you about the requirement after final stage. As you know, in the United States, the after final amendment is limited, and the entrance and consideration of the amended claims, including an additional feature, depend on the examiner's wide discretion. On the other hand, in Japan, the restriction in after final amendment is relatively less strict, and whether the amendment is accepted is more predictable. In general, it is acceptable to introduce a new feature from the spec as long as it narrows the scope of the claim term. Additionally, when amendment, even amendment that does not limit the scope, may be accepted if such amendment is made for clarification purpose, usually against the indefiniteness objection. Additionally, in Japan, you can further amend the claims when filing an appeal decision of refusal. Thus, you have many chances of making substantive amendments even after final stage, which means you have more chances to have the application allowed under the examination of a single application. Third, examiner interview. In my opinion, the interview is quite effective in Japan. Unlike the US examiners, Japanese examiners usually work at the JPO office, the center of Tokyo. It is very easy for you or Japanese attorney to meet with them and discuss the patentability of your application in person. Once you can make an appointment, your or Japanese attorney can discuss the complicated issue such as inventive step. The Japanese examiners tend to consider our arguments based on their best understanding of the invention and embodiments, and JPO officially says the examiner should allow us to conduct the interview at least once in the examination. Thus, it would be beneficial for you to consider the in-person interview, especially when you want the allowance in very important case. Next slide, please. And this graph shows the length of time before the first office action is issued in Japan. As you can see, there is a significant drop between 2012 and 2014. This indicates that now you can receive the first office action within 10 months after requesting the examination. This is very different from the US case. I think it takes over 1 year for the examiner to issue the first office action in the United States. And can you confirm if my understanding is correct?
Yes, you are correct. Right now, the first office action pendency averages 16.3 months as of September of this year.
Oh, so there is a big difference.
Mm-hmm.
And additionally, the total length of time to reach the final decision in Japan, including grant and denial, is 15 months. Again, this is different from the United States case. I think the US examiner requires over 2 years to reach the conclusion.
Yeah, that's usually the case. In fact, right now the total pendency averages 32.3 months in the US.
Thank you. And of course, we cannot simply compare those numbers because each patent office operates according to different laws. But from the statistics, I can say that JPO's decision is very quick and helpful for foreign applicants to pursue the protection in Japan as soon as possible. And now you may have a question, why JPO could reduce the examination time? One of the biggest reasons would be the number of the examiners hired by fixed-term employment. JPO reported that the number of such examiners has increased by 30% over the last 10 years. And another reason is that JPO reduced the examiner's workload by outsourcing of the searching task. Thanks to those policies, JPO appears to achieve reducing of the prosecution period significantly. Next slide, please. Thank you. Okay.
Yeah.
Okay. In this slide, I will show you what subject matter is patent eligible in Japan. Japan patent law stipulates that a product, a process, and the process for producing a product are allowable. Unlike the US, a computer program is considered as a product, and the data structure and the computer model are considered as the equivalent to a program, and thus allowable. However, similar to the US laws, the Japanese law requires the software type invention be described to use some hardware resources. Thus, the basic idea for patent-eligible software invention is not so different between US and Japan. And in my opinion, US claims that have no 101 and 112F issues will meet the requirement of the patent-eligible subject matter in Japan. So if we draft claims considering the software invention issues in the United States, I think you don't have to worry too much about the requirement in Japan. Please go to the next slide. And this slide shows the court system on IP-related cases in Japan. I think the procedure is similar to the United States. As shown in the slide, there are generally two paths for infringement cases and appeals against JPO decision cases. The right part of the slide shows the case of appeal against JPO decision. This is very similar to the appeal procedure in the United States. First, your complaint must be tried by an appeal board of the JPO, consisting of JPO examiners. Then, you can proceed to the IP High Court and the Supreme Court. I will give you explanation about the IP High Court later. The left part of the slide shows the infringement case. You need to file a complaint to Tokyo or Osaka District Court or any other district court, depending on whether the case is technological. If the case is technological, such as patent-related case, Tokyo or Osaka District Court try the case. Otherwise, the other district courts located in major cities in Japan try the case. If you want to appeal the district court ruling, you go to the High Court. As mentioned before, we have the IP High Court that specializes in, of course, intellectual property laws, and it hears the case about technology-related matter, or the case from the Tokyo High Court jurisdiction. If the case is not technological and the case comes from the other High Court jurisdictions, the High Court that has jurisdiction over the area where the court of first instance is located hears the case. The final instance is the Supreme Court for all cases. I am a prosecution guy, so I cannot make any practical comments on this system. But the IP High Court has its website and published a guidebook explaining about the court system and statistics in English. So you can refer to it and learn the basic of the IP-related cases filed in Japan. Please proceed to the next slide. This graph of this slide is one of the statistics indicated in the guidebook published by the IP High Court. The graph shows the chances that the patent that is being enforced survives over the infringement lawsuit. The cases where no defense of invalidity is alleged account for over 27%. The cases where the cases where defense of invalidity is alleged but no judgment is made account for 43%. The case where defense of invalidity is alleged and judgment maintaining the validity of patent is made accounts for over 13%. And the case where to invalidate the patent is made accounts for only 70%. So in sum, I can say that the patent trend tends to survive the defense of invalidity in Japan. Next slide, please. This is the last slide of my part, and I will show you the JPO's policy in the future. Now, JPO specifically focuses on IoT-related invention. They established a team to accumulate and share knowledge and expertise with other countries' patent office and patent practitioner. They updated the patent examining procedure for examining the IoT-related invention. The updated policy encouraged the examiner to consider the advantageous effect of the IoT invention, so we can expect JPO examiners to allow the IoT inventions more proactively. Last year, JPO also established a new patent classification, DIT, which allows us to retrieve information about the IoT-related applications comprehensively. And interestingly, JPO itself is trying to use the advanced technology, artificial intelligence. This April, JPO published their action plan to evaluate the applicability of AI to JPO's operations. In the future, IoT-related technologies will be more proactively patented in a shorter time in Japan. That brings me to the end of my presentation. Thank you for your attention.
Thank you very much, Shige. First I want to remind the audience that questions regarding today's program may be submitted with the question button on the right-hand side of the browser. If you have questions regarding Black Hills IP services, please contact our Vice President of Sales, Jim Brophy. If you want more information about the SLW Institute, please contact their Program Director, Brian Ness. And Shige's contact information is on the earlier slide as well, if you wish to reach out to him. While we're taking a minute to allow people to submit questions, I wanted to just briefly summarize some of the high points that Shige covered. He pointed out three differences in the process between U.S. practice and Japanese practice that I think are significant. The first being that you have the ability to defer the request for examination for up to 3 years. And particularly if you have cost-sensitive clients, that could be a benefit by postponing some of their fees. There is also more likelihood and opportunity to amend successfully after final practice in Japan than in the U.S. And examiner interviews in Japan can be a very effective tool to advance prosecution. Then I think it was very interesting to note the examination time in the JPO is significantly faster than in the U.S., with first office actions coming in at least in about 10 months. And finally, the eligibility for software and computer-related inventions seems to be fairly similar to the U.S. as well, particularly if you have claims that have no 101 or 112F issues in the U.S. So I think those are interesting differences to note between patenting in Japan and patenting in the U.S. So we do have a question that I want to have Shige address. I'll read it. It is, if you nationalize from a PCT application, so if you do a national application, well, a national phase application in Japan off of a PCT, do you still have 3 years to pay the request for examination? So Shige, can you still defer that request for examination if you're filing in Japan off of a PCT?
The answer is no, but you have additional time to submit translation and submit a request.
Okay, so that was a great question then. If you're wanting to use the strategy of deferring examination, that has to be based off of a national application filed in Japan as opposed to a PCT application filed in, coming off of a PCT application filed in Japan. Is that correct?
So could you say that again?
So if you want to defer examination, you have to do that based off of a, you have to have a direct national application filed in Japan as opposed to a PCT application that was then filed in Japan. Is that right?
Yeah, correct.
Okay. Good, thank you. I'm glad that question was asked.
Okay, thank you.
All right, here's another question, and I don't know if you have experience with the patent prosecution highway, but if you do, how does requesting examination along with patent prosecution highway affect the timeline and procedures in Japanese prosecution? Is it better to request patent prosecution highway off of a positive PCT IPR or an issued U.S. case? So is there any difference if you tried to use the patent prosecution highway in Japan based off of a issued U.S. case or a positive report in a PCT application? Do you think there's a strategy there?
Yeah, this is very interesting, and I cannot give you a clear answer right now. But PPH works very well in Japan, and it shortens examination time effectively.
So the PPH program can be a very good strategy just generally in Japan, is what you're saying, right?
Yes, if you use it, I think you will receive the first office action within 2 or 3 months. It's very short. It's very useful.
Okay, good. We have another question about if the slides will be available to download, and they will. We will post the slides and an audio recording of today's program on the Black Hills IP website. Under the Educational Resources tab, there's a Foreign Excellence menu, and the slides and audio recordings of all previous webinars in this series will be posted there. Give us a couple days to get these processed and posted, but they will be available. It looks like that's all we have for questions in the queue. So first of all, I would like to thank you, Shige, for taking time to present, and wish you the best of luck as you're getting used to living in California. And I'd like to ask our audience to please join us for the next presentation, which will be on patenting in Korea. That is on Thursday, December 21st at 1 p.m. Central Time, and you can register for that on our website. Thank you very much, and please join us for the next webinar.